Well, good afternoon. Welcome to this ETOA webinar. It's going to be on crisis and recovery, and particularly in reference to UK employment law. I'm going to wait a couple of minutes just to let everyone log in, and we'll start in about 60, 90 seconds or so. Well, good afternoon. I'm absolutely delighted to be I'm absolutely delighted to be joined today by Madeline Thompson, who's a specialist lawyer specialising in employment law. Normally works in London, but she's joining us today from the heart of Kent, just outside Maidstone, and by Kelly Strong, who many of you will know is a leading recruitment specialist in the travel industry here in the UK. What we're going to be discussing today is employment law, particularly in reference to the government's furlough scheme, and also with the unfortunate necessity that some companies will be facing of letting people go. So we'll be looking at furlough and issues surrounding redundancy. I would like to thank everyone for taking part. Please make sure that you ask questions. There's a question facility on your toolbar there. I'll be moderating the questions, but Kelly very much is going to be moderating the conversation. So whilst stressing that the conversation today is to do with UK employment law, not any other employment law, I'm going to hand you straight over to Kelly. Kelly, over to you.
Hello, and thanks ever so much for everyone joining us this afternoon. The format of today is we're going to be running this for an hour. We're going to start off with the furlough situation as it is now, i.e. up until the end of July. We're then going to talk about redundancy processes. We're then going to open up for any questions of anything we may have missed during those first two topics. And then we're going to go back to furlough and how you bring staff back into the workplace. So I hope you're going to pick up some nuggets of information today. We're very, very grateful to ETOA and all the team at ETOA for continuing these seminars. I've certainly found them really useful. And thank you for watching today. So with no further ado, I'm going to introduce you to Madeline Thompson of the Employment Protect Limited. Madeline had a career of 25 years in the employment law, working mainly for legal companies. And 4 years ago, she set up her own business to look after a number of markets. That includes construction, hospitality, leisure, retail, tourism. And she offers a lot of clients help, particularly, can you imagine how busy she has been the last few months. So we're giving up time this afternoon for us because so many of her clients have been concerned about the impact of COVID-19, putting staff on furlough leave, looking at new employment policies around COVID, and then the process of taking staff off COVID. So we're very, very grateful for her joining us today. We do need to emphasise that the furlough law is currently untested. This is a new term for all of us. And there seems to be some discrepancy between HMRC guidance and the directions given by the Treasury. So there's a little bit of room for interpretation here, and it's going to be up to the courts to decide almost the law as the cases come. So the guidance and suggestions that Madeline's given us today is very much on an informal basis and on her best assessment of the government's advice so far. And there are new guidelines coming out, as you probably all know, hopefully in May, regarding the furlough situation post-July. And that's why we're breaking this afternoon down to the furlough law as it appears to be until the end of July, because there are obviously going to be some changes from July, from August. So if you've got any legal concerns, you should be looking at bespoke legal advice on a more formal basis, all right? But we're going to start with the furlough situation. Madeline and I both had a lot of questions from our clients. So we're basing a lot of the questions in the interview today on what the industry has been asking. So we hope there's a little bit of information. So Madeline, hello and welcome. I'm sorry I've dominated the screen. So.
Thank you very much for inviting me along today. I'm looking forward to sharing some of the experiences I've had with working with my travel clients over the last couple of months on the furlough scheme. And, you know, I think we're all very grateful that the government has brought in this scheme, which has been a lifesaver, particularly for travel. And as you say, it's about applying our commercial sense and best guess based on what we know of what the government intent is on this, and employment law generally, and navigating our way through.
Okay. A number of our clients have been paying the 80% salary of their employees, and a number have been topping that up with the additional 20%. Is there a legal guideline on whether you need to top that further 20% up?
Yeah, so obviously the government is contributing 80%, or for those employees who are higher earners, a cap of £2,500 a month. So some employers, you say, are choosing to top up, but many employers cannot afford to top up. So they are paying the maximum that the government will give under the furlough scheme. And that's fine as long as you've got your employees' agreement to pay at that lower rate. And therefore, if you haven't already, if you're an employer who hasn't got your employees' agreement, but you're paying at the lower rate, then you really should be getting your employees' agreement in writing and keeping it with your records in the event that HMRC might want to see that.
Okay. Some of our members started the furlough scheme at the end of March, some of them at the end of April. However, those that did the furlough earlier wouldn't yet have had the money from HMRC. Do they have to pay the salary regardless of whether they receive that money, or can they wait until that money is in before paying this?
So in an ideal world, you would pay your employees as normal, month by month through the payroll at the normal pay intervals that you would. However, if cash flow is tight, we have seen some employers agree with their employees that they will wait until the money comes through from HMRC before they pay. What's very important is that if you do need to do that, that as soon as you've got the money through from HMRC, you make the payment to your employees, because otherwise it may look to HMRC like there's an attempt to abuse the system, and then that could disqualify you going forward. So it's very important to pay it as soon as you can.
Okay. Thank you. There seems to be a little bit of confusion about sick pay. I wonder if you can talk about short-term sick pay and long-term sick pay conditions.
Yes, so this is where there's this discrepancy between HMRC and what the Treasury has directed, and the Treasury direction takes precedence over HMRC. So there was a perception previously with the original HMRC guidance that sick people on sick leave could be put on the furlough pay scheme. However, when the Treasury had their direction on the 15th of April, any statutory payments such as statutory sick pay or statutory maternity pay are ring-fenced from furlough pay, and so it's not possible for employers to be reimbursed for statutory payments. So if you have an employee on short-term sick leave and the contract of employment says that they would just receive statutory sick pay, then you're not going to be able to get reimbursed for the payment of that statutory sick pay. However, if you're an employer that pays contractual sick pay quite separately from statutory sick pay and doesn't refer to statutory sick pay, then you will be able to get reimbursement for that. And I think if you're an employer that pays over and above statutory sick pay, so normal pay during sick leave, and you say in your contract that includes statutory sick pay, you will be able to claim the sum between statutory sick pay and what you pay out.
Gosh.
I think it's more complicated where you've got somebody on long-term sick leave, because they are entitled to statutory sick pay for 38 weeks. So, 28 weeks. So once they've had their statutory sick pay for 28 weeks, then they've exhausted their statutory sick pay entitlement. At that point, they can be put on furlough leave. Now, when we originally entered into this scheme, that might not have been such a big thing, but now that furlough leave is going to be extended until the end of October, a much longer period, you may find you have employees who exhaust their statutory sick pay within that period.
Another new word that's come up, which is not familiar to many of us, is regarding shielding. And some staff have had letters saying that they fall under within the shielding recommendation, which means they have to stay at home, or possibly someone in their home has a shielding letter, and therefore it makes them looking after a vulnerable person. If someone's being shielded, can you place them on furlough?
Well, you could, before the direction from the Treasury on the 16th of April, before that time, if somebody was extremely vulnerable and was defined as shielding, they were not entitled to statutory sick pay, and so you could put them on furlough pay. However, on the 16th of April, the government, I think, was trying to be helpful and said that these people who were shielding were now entitled to statutory sick pay, which seems like a good thing, but it means that these people on statutory sick pay are no longer entitled to furlough pay. So they're actually going to get less than if they were not entitled to statutory sick pay. But because they are entitled to statutory sick pay, they're no longer qualifying for furlough pay. If you have an employee who is well themselves and has no underlying health issues, but they're living in the same household as somebody who is shielding, they might choose, they might say that they should also be entitled to sick pay. They're not entitled to sick pay, they would be entitled to furlough leave. Although when it comes to bringing them back to work, we will see a little bit later how that can be problematic.
It's going to be a great question to go through. Maternity leave, someone on maternity, can they be placed on furlough?
They can be placed on furlough, but if you only pay your employees on maternity leave statutory maternity pay, then they will not be entitled to any you won't, as an employer, get any reimbursement from the government. It's the same treatment as statutory sick pay. However, if you pay your employees on maternity leave, enhanced maternity pay over and above statutory maternity pay, then that amount that's over and above statutory maternity pay, you can get reimbursement for that.
Okay, lovely. If a company wants to rotate furlough amongst its employees, so bring people in for a period of time and then put them on furlough so they can have continuity of number of staff, are they able to do that?
Yes, so quite a few of my travel clients, because of the various phases of cancellations as the holiday season progresses, have needed to bring employees back for short bursts of time to deal with cancellations. And so you can bring employees back from furlough leave, but you will only be able to get reimbursement for the period they were on furlough leave if you leave them on furlough leave for a minimum of 3 weeks at a time. And 3 weeks means 21 days. So if you have an employee and they've been on furlough leave for 20 days and you bring them back only for 1 day, then you won't be entitled to claim back their salary for that for the 20-day period, because it fell short. It's got to be 21 days minimum.
And that's 21 working days, not days.
No, it's 21 calendar days.
Okay. There seems to be a little bit of confusion regarding annual holiday leave during entitlement. So do they continue to accrue holiday leave? And can companies ask their staff to take annual leave during the furlough period?
Yes, so employees accrue their annual leave as normal during furlough leave. And so this is presenting quite a few queries, because some employees, before any of this coronavirus occurred, will have pre-booked holiday for this period while we've got furlough leave, not knowing that they were going to be on furlough leave. They should still take their holidays unless their employer says you don't have to. So some employees are naturally saying to their employers, well, we were going to take our family to Spain during this period. We're not allowed to. We're all stuck in our home. So we don't want to take it as holiday anymore. I know we booked it, but can I cancel that and have it reinstated to my annual leave? The employer is entitled to say, no, I'm very sorry, you booked that, and we're going to still take it as booked. On the other hand, you've got employers who are thinking, well, when this furlough leave is over, everybody's going to come back and they'll have accrued potentially up to 8 months holiday. And the last thing we want is everybody wanting to take holiday all at once, particularly if, in travel, hopefully we'll come back from furlough leave and everybody who's been locked down will be desperate to go on holidays. And we should have our very busiest period ever. And we're going to need all our reservation staff, everybody in the team. We can't afford for them to take holiday then. We'd like them to take holiday now. So the employer can say to staff, we want you to take your holiday while you're on furlough leave. But if you're an employer who wants to do that, you have to give your staff a minimum of twice the period of advance notice as the amount of holiday you want them to take. So if you want an employee to take 2 weeks holiday, you must write to them 4 weeks, twice the period of holiday, 4 weeks in advance, to say we want you to take holiday of 2 weeks in 4 weeks' time.
Can the employee say, no, I don't want to take holiday during furlough period?
Yes, an employee can say they would rather not to. They can't. The employer has the final say on it. But if an employee says, "Look, my children are at home with me, and I'm having to help them with their education, and they have got to do their schooling. We cannot go on holiday at the moment because it's term time," then I think it would be unreasonable for the employer to insist that they take their holiday then. But if there are no solid reasons such as that which prevent the employee from being able to take the time as holiday, then the employee will need to take the holiday as requested.
And what's the view about annual leave entitlement being carried over, say, to next year?
Yes, so what the government's done is it's introduced some new legislation which says that if you're an employee who's been prevented from taking your holiday during COVID-19 period, then you're entitled to carry over up to 4 weeks of your annual leave for the following 2 years. So that is extremely helpful. So it means people will be able to take more holiday leave potentially next year and the year after. Although again, when an employee makes a holiday request, if that period they're asking for is not convenient for the employer is entitled to say, I cannot agree to you taking your holiday at that particular time, but you can take it after this seasonal period or later in the year.
That's so reassuring, because a lot of people are so concerned that when we get to the stage where we can reopen businesses, that the expectation was that lots of staff then would want a holiday, which would have really killed business. So that's very clear. Thank you very much. We are going to come back to furlough, but the current situation, unfortunately, has led to a lot of companies to either start doing redundancy processes or having to think of them. And we thought we'd cover the redundancy section in this as well for the UK. While someone is being furloughed, can you start the redundancy process then?
Yes, employers are being confused about this because the whole purpose of the furlough scheme was to help employers not to make redundancies. And so some employers have said, well, does that mean I can't make any redundancies? But yes, employers can make redundancies. And in fact, in some cases, I've got employers saying, I feel that I know that I need to close down a whole department, for example, or a number of employees I've already decided that unfortunately we'll have to make them redundant. Because the furlough leave scheme has now been extended until the end of October, I feel morally obliged, because of my relationship with those employees, to keep them employed until the end of the furlough scheme. But there are difficulties with that, and partly because I think some employers don't realise how redundancy termination payments are calculated, particularly statutory redundancy payments. So the statutory redundancy payment is calculated according to a formula, which is the number of full complete years of employment that the employees worked, multiplied by a factor for their age, and multiplied by 1 week's gross basic pay, limited to a statutory cap of £538. So now that we've got this longer furlough leave period to the end of October, it's likely that quite a lot of employees will accrue an additional year's employment during this furlough period, which will add to the calculation, because it's the number of years multiplied by the age factor multiplied by the week's pay. So for example, if you've got an employee who's worked at the company for 3 years and their age, for example, age 30, and they're on £500 a week, the formula is going to be 3 years, 3 for the 3 years, 1 for the age factor, and £500 for the gross basic week's pay, which is going to give them £1,500 statutory redundancy. But of course, if during the next few months they accrue a 4th year of employment, then it's going to be 4 times the 1 times the 500, and if that's for each employee affected, then the statutory redundancy costs are going to go up at a time when the business may well be loss-making. And another misconception that some employers have is a lot of employment contracts will stipulate what the notice period is, and the notice period is commonly 1 month's notice. But statutory notice takes priority over contractual notice, and statutory notice is 1 week's notice for each completed year of employment. So that 1 month's notice is fine if you've got employees who have been employed 4 years or less, because that 1 week for each year will take them up to 4 weeks. But once they've been employed 5 years, they're entitled to 5 weeks notice. And then if they've been employed 6 years, 6 weeks notice, up to a maximum of 12 weeks. And so again, if during this period of furlough leave, the employee accrues an additional year's notice, that gives them an additional week's notice pay. And so that, with the additional statutory redundancy cost, is something that the employer may not have budgeted for when they're considering whether they can afford to keep the employee on for the entire furlough leave period.
I'm thinking of lots of questions, but I'm not sure I'm allowed to ask them. I might ask them at the end, because I'm thinking of all sorts of scenarios there. A lot of our members have less than 20 staff, so they don't have HR managers, and I think they find it really valuable if you could perhaps talk about the process if you were making a number of those staff redundant. Is it the ceiling of 20 where it's slightly easier, or is it a little more than that?
Yes, that's right. So if you think you might need to make 19 people or less redundant, then it is a much more straightforward procedure than if you think you may have to make 20 or more redundancies. And it's very strict. You know, if you make 20 people redundant and you thought it was going to be 19 when you started the process, but it ends up being 20, then you know it's a completely different procedure that you should have used. So the simple procedure for 19 or fewer redundancies is what's going to apply probably for most of the members. However, if any of those employees have been employed less than 2 years, then you don't have to adopt any procedure at all. But if you're going to be making a number of redundancies, say if you're going to make between 10 and 19 redundancies, you may decide to follow the consultation procedure even for those less than 2 years, but you really don't have to. So assuming that you've got employees who have been employed over 2 years or 2 years or more, then the procedure is very simple if you don't have to adopt a selection process. So, for example, if you are going to make standalone positions redundant, for example, managers, you might have an IT manager and you think, right, we're just going to have to do without an IT manager, or we've got a marketing manager, we're just going to have to do without a marketing manager role. If there's nobody else who undertakes those roles, it's quite a simple procedure, which I'll go on to shortly. However, if you've got, say, a reservations team with 5 people in the team, and you think you may need to reduce that team to 3 people in the team, then you are going to need to go through a selection process whereby all 5 members of the team go into a selection pool and you select, and that's a more complicated procedure. So I'll go back and we'll start with the simple procedure where there's no need to select between employees. And this is the basic procedure. The employer needs to write to all the employees affected, each of them on an individual basis, and explain that owing to the COVID-19 situation, the business is losing money and needs to cut costs. And that unfortunately, that employee's role is proposed as at risk of redundancy, but no final decisions will be made until consultation has taken place. In that letter, the employee needs to be invited to a consultation and what would normally in real life be a meeting, and we'll go back to that, the time and the date of the meeting. And then the employee needs to be advised that they're entitled to be accompanied at that consultation meeting by a work colleague or a trade union representative. And they need to be advised that at that meeting, they will have the opportunity to have their say as to ideas they have about, about keeping that role and what they can bring to the table, or perhaps considering alternative employment with the business. And even if the employee doesn't consider there's any alternative employment, then the employer does need to look and consider whether there are any alternative roles. So, as I said, normally that would be a face-to-face meeting, but owing to lockdown, most employers now are having to find different ways of having these consultation meetings, which may be a Zoom, Skype, WhatsApp call, or it may be that the employee doesn't feel comfortable with those kind of media and may prefer a phone call. So the employee should be given that choice. And if the employee wants to be accompanied by a trade union rep or a work colleague, then those kind of conference facilities need to be inbuilt. So the meeting takes place, and then the employer should not make any decisions until after that meeting has taken place.
How long can you make a decision? How long after can they make a decision? Is there a time limit?
Yes, certainly by the next day, the employer can have made the decision, but should be seen to at least think about it and not make any immediate decisions, because they need to think about what the employee has to say. And then after that, the employer has to notify the employee in writing of the decision. And if that decision is to terminate their employment for redundancy, they need to set out when the termination date is going to be and what payments the employee will receive on termination. That would be their contractual payments and also their statutory redundancy payment, and what will happen about any holiday pay that they're owed. And then the employee must be told in that decision letter that they have a right of appeal. And normally the employee is given 7 calendar days to appeal against the decision. And if the employee does do that, then an appeal hearing needs to be set up, and somebody other than the person who made the decision on the redundancy should hear the appeal. And that person who hears the appeal should normally be somebody who is at least as senior as the person who made the decision to terminate employment for redundancy.
It's a very small company and that the company's making everyone redundant. How do they get someone else to do that appeal?
If they have any non-executive directors, they could call on them. If not, then sometimes companies will look externally. For example, their accountancy or auditors, they might be able to provide somebody who can hear the appeal, or it may be that another travel company that they're associated with, one of the directors from there could come across. It needs to be somebody who's obviously got the experience and gravitas and to make the decision, and somebody who's can be seen as an independent thinker who can review properly the decision that's been made and overturn it if need be.
Just stepping back slightly, if a company is sending letters to their staff discussing redundancy, how quickly can they then arrange the meeting with the staff?
I think a minimum period of 2 working days between sending them the letter inviting them to the consultation meeting and the consultation meeting taking place, because the employee will need time to, if they want to find somebody to accompany them. If the employee in normal times wants to be accompanied by a work colleague and that work colleague is unavailable because normal circumstances they might be on holiday, then the consultation meeting would have to be adjourned for up to 5 days to allow that person to accompany them, no more than 5 days. But in lockdown, I don't think anybody would be unavailable to attend, so I don't see that there would be reason to extend the period.
Okay, and once the process has been agreed and the redundancy is made, when does that redundancy payment have to be settled?
Right, the redundancy payment would normally be paid in the first payroll immediately after the termination date of employment. If the employer can't afford to pay it then they should explain that to the employee and hopefully be able to agree a time when it will be paid, maybe the next month. If an employer is in a situation where they really cannot afford to make statutory redundancy payments, they are liable to pay them. But if the employee wants to enforce that payment, then the normal course would be to apply to an employment tribunal. But employment tribunal hearings are, even before the coronavirus pandemic, they were taking about a year to get to hearing, and it's going to be a lot longer now because all the tribunals are closed and hearings aren't taking place. So it may be that employees will have to wait possibly 2 years, even longer, to get their hearings, which is awful for employees, but perhaps will give employers time to get back on their feet and make those payments well before that hearing would have taken place.
Can statutory redundancy payments be claimed back under the job retention scheme?
No, they can't, because they're not considered to be salary, so they can't be paid back.
Okay.
But there is some flexibility with is notice pay. So normally contracts of employment will provide that the employee is entitled to so many weeks or months notice, but will also say that the employer has an option to make a payment in lieu of notice. So for example, Kelly, if you were my employee and you were on a month's notice and I was thinking of terminating your employment today, which is the 16th of May, I have a choice to say to you, Kelly, I'm terminating your employment. Your employment will end in months' time on the 15th of June, and I'm going to keep you on furlough leave for your notice period. If I say that, then as your employer, I will be able to get reimbursement for that notice pay through the furlough scheme. However, if I say, Kelly, I'm afraid I need to terminate your employment, and I'm going to terminate it with immediate effect from today, but don't worry, I'm going to pay you your month in lieu of notice in next week's payroll, then because you won't be employed for your notice period on furlough leave, I won't be able to get the reimbursement from the government. So if employers want to get reimbursement for that period of notice, then they must keep the employee on furlough leave during that period of notice and not pay them in lieu of notice at the beginning.
If some companies panic and they decide to start the redundancy process now because they fear that the furlough through to October won't be paid for by HMRC. Once they've started the redundancy and agreed the redundancy, if something strange happens in August and the government goes, oh, we're going to pay the whole 80%, can you withdraw the redundancy notices? Or can the staff go, well, that I've worked there 10 years, that's a great redundancy, I'll take my risk and try and find a job somewhere else?
Well, there are a few ways of looking at this. So first of all, if you start the redundancy process, it means that you would start consulting with the employee. Now, when I gave you the very simple procedure earlier, that gave you just one consultation meeting with your employee, and that whole procedure might take place within under 2 weeks. However, the employer can have as many consultation meetings before making its decision as it likes, and can extend that consultation period for weeks if need be, if it wants to assess the situation, if it's hoping, you know, things might change, there might be an easing of the restrictions on travel, for example. So that might happen. However, if the employer does make the decision sooner rather than later and serves notice of termination, then if things improve and the employer thinks, oh, that's really good, we really want to keep this employee, then the employer will need to say to the employee, we'd like to withdraw your notice, and then it's up to the employee to agree to that at that stage.
Okay.
I mean, the only way, a different way, I suppose, the employer could, they could, if they were paying over and above statutory redundancy, they might stipulate when they give notice that they're paying over and above statutory redundancy, and if the job actually becomes available before the end of the notice period, that they would withdraw the notice and no redundancy pay will be payable if they withdraw notice. But that if the employee wants to leave anyway, they'll only get the statutory redundancy pay. So it would have to be very carefully worded, the termination letter, if you wanted to keep that option.
Right. For the moment, the final question on redundancy: if a member of staff is paid a salary but then earns a considerable bonus paid either monthly or quarterly or yearly, is the redundancy package based on the basic salary, or do they have to take into account the annual bonuses?
Statutory redundancy is based on basic pay and not bonuses, unless unusually the salary provisions in the contract stipulate that bonus is part and parcel of basic salary, but I haven't seen anything like that for a very long time, so I doubt that would apply.
Basic salary, lovely. Well, that's a lot to take in so far. I wonder if we can go back to Tom and see if there's been any questions so far that we can help with.
Well, we have a few questions. Many of the questions have been covered in your discussion. They were almost anticipating the flow of information which has been occurring. I have one or two particular ones, though. I mean, do furloughed staff have to be paid full contractual salary if they take holidays on furlough? They're on furlough, they say, right, I'm going to take my holiday now, you're making me do this. Are they entitled to have their full pay during that period, or well, what happens?
The guidance certainly gives the impression that there is an expectation that they will be paid full pay, but case law and statutory law and working time regulations doesn't necessarily follow what the furlough leave guidance is on this, and I think this is where there is going to be some dispute in courts at a later time. So the safe thing to do for the employer is to pay the full pay, but obviously some employers can't afford to do that at the moment, and therefore, because the working time regulations suggest that, so the working time regulations say that during your holiday you should be paid what you would have been paid during that period of time. Now, if employees have agreed under furlough leave agreements that for this period of time they will only be paid 80% of their salary, then many employment lawyers believe that the working time regulations mean that they're only entitled to 80% of their salary for holidays. The HMRC guidance, particularly the one that came out yesterday, recommends, well, really says that employers should be paying full pay. But I think this is where there will be case law in the future. And what employers are saying to me is, we can't afford to pay full pay, so we're going to pay 80% and see what the courts say at the end of the day. Or perhaps in a few months, if we're doing better and we can afford to pay it, we'll pay it then, but we're just not at the moment.
Right. Another question that's cropped up is, you mentioned that for staff with less than 2 years employment, there are no redundancy procedures, but they're wondering what would be the advice to regards to best practice in such cases, and will the employee be entitled to any statutory redundancy pay? That's if they've worked for less than 2 years. I mean, what's the best thing to do for these people?
Okay, well, first of all, while I remember to do so, I really wish to clarify the 2 years, because this is something that gets a lot of employers into difficulty, and it's one of those strange legal anomalies. So 2 years doesn't actually mean 2 years. 2 years means 1 year, 51 weeks. So if you have an employee who has actually worked for you for 1 year, 51 weeks, but hasn't quite accrued that additional week to 2 years, then they get the benefit of 2 years. So when I say 2 years, I mean people who've worked for less than 1 year, 51 weeks. So having got that out of the way, that those employees are not entitled to a procedure for their redundancies, and neither are they entitled to statutory redundancy pay. They are completely ineligible for statutory redundancy pay. Some employers may find that they only want to make very few roles redundant, and that the cheapest way for them to do that is to actually make those who've only been employed a very short time redundant, because they don't need to go through a procedure and there are no statutory redundancy costs. And therefore, if you're only making those employees redundant, there is a temptation to think, actually, we're so hard pressed against it at the moment, particularly in travel, and we've got all these cancellations, we've got no time to go down a procedure, and so not to go down a procedure. But I would think that if you're going down a procedure for some employees anyway, because they have been employed 2 years, then, you know, it may be that there's no difference to actually apply that procedure to those that are less than 2 years, but there's certainly no legal requirement to.
Right, thank you. Another question is, I'm just interested, someone wanted to know if statutory notice supersedes contractual notice.
It does, yes. So again, this is something that employers sometimes don't know. They think they've got 1 month's notice in their employment contracts, and they only give 1 month's notice. But if you've got somebody who's been employed with you 10 years, they're entitled to 10 weeks notice.
It's that was a very simple question. Please ask more open questions, everyone. We've got, if you have to do a collective redundancy, will the 2 years still apply, or will we have to pay all notice plus statutory redundancy plus holidays? I assume what that question is that if you're doing it, if you're doing it to a lot of people, do you have to treat them in exactly the same way, or are you allowed to treat them in a different way given the length of time that they've been working?
Okay, so if you think you might be making 20 or more redundancies, even those with less than 2 years employment, they all count towards that 20 or more, then you need to consult with everybody via the collective representatives. So you have to apply the collective consultation process, which for up to 99 people is a 30-day minimum consultation process before you can start making dismissals. And if you've got 100 people or more affected, then it's a minimum of 45 days consultation period before any dismissals can be made. But before you can start that consultation, you have to give your employees the opportunity to elect representatives unless you have a recognised trade union involved, and then you can consult with trade union reps. But I think most of the members do not recognise trade unions, and I think really it's going to take a minimum of a week to organise for your employees to elect representatives. And normally the employer will say how many representatives there will be. So for example, they might say there'll be one elected representative for each department, and then each department affected elects their rep. And then the employer starts consulting with those collective representatives before then eventually consulting with the individuals, then terminating employment. You can terminate employment before that minimum of 30 days, as long as the dismissal doesn't take place until after that 30-day period. But you must have had meaningful consultation before you make that decision and serve notice of termination.
But just to clarify, you can still almost differentiate between the individuals, between those who've had who are entitled to statutory redundancy pay, who've worked more than 2 years, and those who are less than 2 years. You don't have to give everybody the same sort of money. No.
No, not that they won't be. So those less than 2 years won't be entitled to statutory redundancy pay, but they are entitled to go through that consultation process before their employment is terminated. And if they're not included, or if there is anybody who doesn't get the benefit of that collective consultation period for a minimum of 30 or 45 days before dismissals are made, they can apply for what's called a protective award, which is up to 90 days gross basic pay as compensation. And that includes those employees who have less than 2 years employment. So employees with less than 2 years employment have no unfair dismissal rights, but they do have the right to apply for a protective award if they haven't had the collective consultation period applied. Now, there are some employers who are particularly in dire straits, and if they have not got time to comply with those minimum consultation periods, they have got the default position of a defence called special circumstances defence. And if the employer can demonstrate that it just was not reasonably practicable because of their financial circumstances, for example, for them to comply with that 30-day minimum consultation period, then that will be a good defence.
Okay. That's really helpful.
There are several questions coming on this, but these circumstances, and for the purposes of the industry, these are special circumstances. These are a larger company is making more than 19 people redundant at any one moment. The question that's just been popped up is, do you have to count staff under 2 years in the group of staff redundant up to 19 total? So if you have, it doesn't matter in the count, sorry, does it matter in the count? I'll rephrase the question. Does it matter in the count that those 20 people include people under 2 years and over 2 years? Or is it just staff and there are 20 of them, these new rules apply?
It's just staff, although I have had clients where they've said, right, we want to save as many jobs as possible, but we're going to let all those under 2 years go. And we think if we let all those under 2 years go, then we'll be able to save everybody else. So they've let everybody under 2 years go without following any process. And then a month later, they say, you know, things are worse than we thought, and we are now going to have to look at staff over 2 years. And therefore, those under the 2 years, they didn't count. They didn't count because they weren't in that thought process at the time. Although they will count if the new redundancies are going to be made within the 3-month period. But if, for example, at the point they made the under 2 years redundant, they had 19 of those, and they made all 19 redundant without any process, then that would be fine, and didn't count then, but will count within a 3-month period. But if 3 months elapses and then they look at a new batch, then they won't count.
So there's a 3-month rule.
It's quite complicated.
This is a very morose conversation, but it's a necessary one. I'm just trying to see if there are any more. There are more questions. One moment.
Let's look at some positive things. Should we start looking at furloughed employers and bringing them back to work? That might be happier times that we can start thinking of. If a company...
Can I just there's one very vague question which has cropped up. Just to clarify the 3-month rule. When does the 3-month cut in? Someone's going to be has made staff redundant 2 months ago, and is going to make another. Well, let's call it 15 staff very shortly. How long does he have to wait for? Does he have to wait 3 months for the consultation, or does he have to? Is it 3 months from the moment of redundancy?
From the dismissal.
From the date of dismissal.
I think so. I won't have to double check that one, but I think it's from the date of dismissal.
So it's from the dismissal of one to the dismissal of the next one. Thank you. I think, Kelly, you're quite right. Let's step on to another area. Please keep the questions coming in, because we'll have time for questions.
Just wary about time. We've got about 10 minutes left, and we've got quite a lot to get through, because we're in a situation now where companies are starting to look at how to plan for the return of furloughed staff back to work. So if an employer wants to bring an employee back to work before the furlough period finishes, can they?
Yes, they can. They can bring them back whenever they like, but they just need to bear in mind that if they want to recoup from HMRC their salary for the period they were on furlough, they must be on furlough for a minimum of those 21 calendar days. But an employer can bring employees in and out of furlough as they choose.
Okay. If an employer is phasing the return of its employees, how should an employer select which employees return ahead of others?
As fairly as possible. I mean, there will be some roles that are standalone roles where, you know, it's easy to determine. But if you've got, say, for example, you've got a reservations team and you've got 10 people in that reservations team, but you actually only need 5 of them at a time, then it's good to rotate them. If you need them in the office, obviously you've got to take into account your ability to maintain that distancing. And so sometimes you might want to put them on shifts, even at different times of the day, so that you can spread them out. But what's important is that employees feel that they've been treated fairly, and you don't want employees complaining that they're repeatedly the ones that are called back in and their colleagues are at home earning the same money but not doing anything. And also you need to think further down the line if you may need to make some redundancies. You know, if you've called the same people in all the time, it might indicate, you know, that they're safe when perhaps they're not, but their colleagues might think so. Conversely, you're going to have some employees who you want to call in to work, and they're going to say, please can you call other colleagues in instead, because there's a member of my household who's very sick at the moment and I want to be with them, or I've got my children at home and I need to help them with their education. And so I would rather, if you don't need me, you don't call me back in. The employer can take that into account in making that decision, but it is the employer's call at the end of the day.
Okay. What policy changes should an employer consider when bringing staff back into work?
I think there's a whole host of policy changes here, and I think the employer needs to decide whether it's best having a wholesale furlough, a COVID-19 agreement that deals with furlough leave, deals with bringing back people on rotation, deals with how sick leave, once people are called back in, how sick leave is going to be dealt with, particularly coronavirus related sick pay, sick leave, self-isolation, quarantines, holiday leave, all that stuff, whether they deal with it in one COVID-19 agreement or whether they go through all their policies and amend their sick pay policy, their sick leave policy, their holiday leave policy. You're also going to need a policy, because if you're bringing people back into the office, obviously the employer's got to do a whole health and safety risk assessment first and ensure that the hygiene arrangements are there, that the distancing arrangements are there. But you may have employees come in and they might say, I don't think it's safe to work here. Now, that would be a very serious allegation. So it's very important that the employer has done that health and safety risk assessment first and assured itself that it is safe. But of course, if the employee feels that it's not safe, then normally those kind of matters would be dealt with under the whistleblowing procedure. But most travel companies, they probably never had a whistleblowing claim ever, and they might not have a whistleblowing policy. So it might be better to deal with that kind of, if employees have got a coronavirus health and safety concerns, that has its own procedure and it needs to be raised with, perhaps a managing director or the HR manager or the health and safety manager, whoever is the most appropriate person. I think that needs to be made solid. The other thing I think we're going to see is we're going to see more people asking if they can work from home after this. So a work from home policy and possibly more flexible working applications, so flexible working policy. You're going to have parents who, even when schools reopen, if suddenly there are too many teachers who are self-isolating, they might have to close the school down and the parent might need to take leave, and that might well be unpaid leave. But again, time off for family independence, parental leave policies, they're all going to be affected by this. And that's why I say you might find it's best to have a COVID-19 policy rather than have to completely rewrite your employee handbook.
Some companies might have not been as up to date with their employment contracts as they should. And in fact, people that have worked there for a long time might have slightly different contracts in employment than people employed in the last 2 years. Are companies able to complete everyone's employment contract to include situations like if there's a second wave of COVID, or do they have to get the employees' agreement to get those employment contracts changed?
Yes, I mean, even in normal times, and this would apply now, if employers want to harmonise contracts because they've got different contract forms for different employees, that's something that can be done. However, if they're going to be significant terms of contracts that the employer wants to change, for example, pay, we've got quite a few employers thinking, if we're going to get back to work, we need a permanent reduction of pay or a temporary reduction until perhaps this time next year, when hopefully we'll be back to normal, but we need a year's worth of reduction in pay. Or they might want to change the holiday leave provisions and the way that people request holiday leave, that seasonal periods, for example, Christmas and New Year period where lots of holidays are booked, that's going to be a period now where people can't take holidays. Any significant changes like that, the employer can only accomplish it if first option, hopefully the right option that everybody will go for, is the employee agrees to it. But if the employee won't agree to it, then the employer needs to enter into formal consultation with that employee or all of the employees who won't agree. And then if following that consultation, the employer still needs to do it in order to remain financially viable, the employer is entitled to enforce that change by serving notice of termination of the current contractual terms and simultaneously at the same time offering the employer the new employee the new contract. And then if the employee does not accept the new contract at the end of that notice period, their employment will terminate. And that should be a fair termination if the employer has the economic organisational reasons to do so, right, and properly consulted with the employee. Okay. However, one word of warning, if you're looking at changing significant terms of contract for 20 or more employees, then you will need to go through a collective consultation process with elected representatives.
I'm amazed how quickly our hour has come up, Madeline. Have you got anything else you'd like to add before we pass on to Tom and any last minute questions?
No, just that, I would repeat that these responses that have been given on the basis of the questions that my clients have been asking, your clients have been asking, and we've been discussing it in this informal environment. But I really would recommend that if any employers or employees need legal advice tailored to them, that they do take independent legal advice, because that independent legal advice will be tailored to them and covered by a policy of insurance.
Thank you very, very much. Tom, over to you.
Thank you very much indeed, Madeline. I have one last question. You mentioned that statute law supersedes contract law, but does that apply when you've got a contract with the employee saying you've got 3 months notice, but they've worked for you for 3 years? Can you say, I'm giving you 3 weeks notice because that's what statute law says? You can ignore the contract. Can you do that?
No. It's what the statutory only trumps the contract if the contract's less beneficial. So if you've got 3 months notice and you've only been employed 3 weeks, you're entitled to 3 months. Yeah. Unless it's gross misconduct situation. Okay,
we've run out of time. It's extraordinary that we've managed to fill an hour with a very dry subject, but you've done it amply. I think you've done it real justice. I would like to thank both Kelly and Madeline for covering what is a really complex and sensitive issue with real dexterity and grace, and it's taken real sensitivity, this. I hope people have found this constructive. We will try and answer any unanswered questions on the website. Thank you very much, and we look forward to you on the next webinar. Thank you very much, Madeline and Kelly.
Bye.
Take care, everyone. Take care. Be safe.
Be safe.